You appear for the claimant or for the
For a defendant.
defendants?
Yes, only.
Okay. This matter is for judgment. The judgment of the court is ready and it will be read shortly.
As court pleases.
This is the judgment of the court. The claimant approached this court on 30th day of March 2022, bear her general form of complaint along with statement of facts, witness statement on oath, list of witnesses, copies of list of documents, and copies of documents to be relied on at the trial. There is also filed along with the general form of complaint a motion of notice for summary judgment, to which the defendants file counter affidavit to show cause why the matter should be heard on the complaint. By the paragraph 10 of the amended statement of facts, which was amended by the order of court made on 29th day of January 2025, which was filed on the 16th day of April 2024, the claimants pray for the following reliefs. They are: one, the sum of 10 million naira and 69,000 naira, 10,069,000 naira, 220 naira, being claimants' gratuity already computed by the defendant pending payment. Two, the sum of 1.5 million naira for legal services rendered by the claimant counsel in term ICFI and associate who gave in favor of the claimant. Three, interest at the rate of 10% per annum from March 2019 till the date of judgment, and thereafter 10% per annum until the entire judgment debt is completely liquidated. The defendants filed their statement of defense on the first day of November 2022. This process was accompanied by a defendant list of witnesses, witness statement on oath, as well as list and copies of documents to be relied on at the trial. The claimant reply to the statement of defense was filed on the 16th day of April 2024. The claimant testified in proof of his case as CW1 and tendered Exhibit A to N in evidence. The claimant was cross-examined and thereafter discharged. One Boniface Abue Eze testified in defense of the defendants as DW1. DW1 adopted his written statement on oath as his evidence in this case. No document was tendered through DW1. Under cross-examination, DW1 testified that he is not opposed to the claim of the claimant being paid, claim of gratuity being paid to the claimant, and that he is aware that the claimant had not been paid her gratuity. All the documents tendered by the claimants, he also stated that all the documents tendered by the claimant are genuine. The case of the claimant, I will skip reading the case of the claimant. The case of the defendant, I will also skip reading it. The submissions of the defendant, OOA Bank Senior Counsel, Ministry of Justice, Calabar, appearing for the defendant, adopted the final written address filed on the 9th day of October 2025 as his argument in this case. In the final written address, a single issue was formulated for determination. Argument canvassed in the in the address have been captured in the body of the judgment. So I will skip reading the argument. I now goes to the submissions of the claimant. K. Intem Ikpi Esquire, counsel for the claimant, adopted the claimant's final written address, which he franked as his argument in this case. In the written address, a single issue was formulated for determination to it whether claimant has discharged the onus of proof to be entitled to judgment on the relief sought. The argument of counsel on the single issue has been captured in the body of the judgment. So I will skip reading the argument. I now go straight to the court decision. I have considered the processes filed by the parties, the evidence presented by both parties, including oral and documentary evidence. I have equally considered the written and oral submissions of counsel in adumbrration of the positions of their respective clients. The facts that necessitated institution of this case are not complex, they are straightforward and not in dispute. The claimant was employed into the service of the defendants as a student midwife on the 5th day of March 1984 and retired as a director on the 5th day of March 2019 on salary grade level 16 after 35 years of service. Thereafter, the claimant has been receiving her pension but is yet to be paid her gratuity despite several demands. On the part of the defendant, they about that the claimant did not inform government when she is due to retire from service and continue to receive salary after retirement, and that she is indebted to the defendants for laptop she received while in the service and was yet to liquidate the payment. They also abide in their pleading that there is no time frame for which gratuity will be paid as payment is ongoing, and that government is making effort to clear the backlog of gratuities owed retired civil servant, and this is done in batches according to their year of retirement. Also, the defendants, the claimants about that the claimant and her counsel are, are a married couple. So his wife could not have paid him any professional or legal fees to conduct proceeding on her behalf. There is no they also about that there is no prior agreement between the parties in this suit as to the interest and cost of litigation claimed by the claimant, and the claimant's claim is premature and done in bad faith. It appears there is agreement by the parties that the sole issue for determination borders on proof of entitlement to the reliefs being sought by the claimant. The gratuity constitute, let me say here, the gratuity constitute a terminal benefit and forms part of conditions of service for civil servants who retired under pension schemes that existed before the Pension Reform Act 2014. Such entitlements are vested contractual rights that crystallize upon retirement and cannot be unilaterally withheld or delayed by the employer. In the case of New Nigerian Development Company Limited by versus Daniel Ugbede, the Supreme Court emphasized that retirement benefits include gratuity and pension and are regulated by applicable status and circulars, and that the employee are entitled to have their benefit computed and paid in accordance with the law governing their employment at the time of retirement. The claimant retired in 2019 after 35 years of service under a pension scheme operated before the Pension Reform Act 2019. Her entitlement to gratuity is governed by the terms of service applicable to her retirement, which constitute binding contract. The law is settled that a party who seeks a court to who seeks a court who seeks judgment from the court regarding any legal rights or liability dependent on the existence of assertions or asserted facts must prove that those facts exist. This is supported by Section 131 of the Evidence Act. In this suit, the main claim of the claimant borders on non-payment of gratuity since her retirement in 2019. In the circumstances, the claimant has the burden of proving her entitlement to gratuity by adducing credible and conclusive evidence to demonstrate its entitlement. See Section 131, subsection 2, 132, and 1 of the Evidence Act. Proof proof, proof in legal parlance is the process by which the existence of facts is established to satisfaction of the court. This principle is highlighted in the case of Jega versus Ekpenyo. Evidence is considered credible when it is okay. Sorry, thank you. Evidence is considered credible when it is worth of belief and conclusive. It leads to definitive outcome. I'm sorry, please give me a minute to take water.
Oscar, places. Sorry.
Sorry, my lord. Sorry, my lord.
Yes, okay, I'm sorry. I'm having kata.
Sorry about that one.
Sorry.
Yes, evidence is considered credible when it is worthy of belief and conclusive when it deals to a definitive outcome. Such evidence must be strong and not contradicted by the opposing party, as noted in the case of Jega Supra. It is important to note that while civil cases are decided based on preponderance of evidence, that evidence must be admissible, relevant, and credible. It should be conclusive and provide a level of certainty that align with the circumstances of the case at hand. CABC Transport Company Limited versus Omotai and Ayaru versus Mandilas Limited, and that of KD Ventures Limited versus Minister of FCT. The claimant, in an attempt to prove her case, tendered in evidence documents which were admitted in evidence without objection from the defendant, and they were marked as Exhibit A, B, C, D, E, F, G, H, I, J, K, L, M, and N. I note Exhibit F was claimant's application dated 21st day of September 2018. See seeking for approval for retirement from service. I also note that Exhibit H was issued in the name of the claimant on 19th day of March 2019, conveying approval given for payment of gratuity to the claimant to the tune of 10,769,220 naira for her services to the state from 5th day of March 1984 to 4th day of March 2019. I am satisfied by this document exhibit Exhibit H, Exhibit F and H that the claimant has satisfactorily proved that she is entitled to gratuity for services she rendered to the state government. The claim of the claimant was corroborated by the evidence of DW1 under cross-examination, the only sole witness of the defendant, who testified that the claimant is entitled to her gratuity and he is not opposed to the payment of her gratuity. The law is right. What is admitted need no proof. The defendants having admitted the claim for gratuity through their only lone witness, they are bound by the said admission, and the claimant has established her claim for gratuity without more. The defendants in their defense have asserted that the claimant did not inform government of her retirement and she can continue to receive salary even after retirement. This claim was not backed by any evidence. In fact, Exhibit F and H have exposed the fallacy in the claim by the defendant that the claimant did not inform the government of her retirement and also that she continued to receive her salary after retirement, as there was no such evidence from the defendant to prove their assertion. The defendant have also in their quest to continue to deprive the claimant of her legitimate entitlement of gratuity for meritorious service rendered to the state, have alleged that the claimant is indebted to the defendant for a laptop computer given to the claimant while in service and yet finished paying for the said laptop computer. The defendant assertions that the claimant is indebted for a laptop computer given by her during her service seems to be raising question of whether the said debt can be set up against gratuity. Under there are provisions made under the provisions of this code for set up and in law for a setup to be recognized, there must be mutual debts existing between the parties. However, the party claiming setup must establish that a valid debt exists, that the debt is liquidated or easily ascertainable, that both debt arose from the same transaction or are connected. In the present case, the defendant has merely alleged that the claimant owed money for a laptop without proving evidence of, of the existence of the said debt. The value of the alleged debt was not also stated, whether there was contractual obligation to return the laptop or pay for it upon retirement. All these are absent. Whether the laptop was provided as part of claimant's condition of service or as personal benefit subject to return have not also been made clear. I am of the firm belief that without proper pleading and proof, this bare allegation cannot constitute a valid defense for setup or deprive the claimant of entitlement to gratuity. The defendants, having not established existence of the debt through proper counterclaim, evidence, and valuation, cannot justify withholding of the gratuity of the claimant. In the case at hand, the claimant has successfully, by the exhibit K, L, M, and M, established that she has paid for the laptop given to her while in service, as the payment was made through deductions from her salaries. The defendants, having not adduced any iota of evidence to counter this claim, to justify their claim of indebtedness to the indebtedness of the claimant to the dependent cannot be had to rely on this phantom claim to whittle down the claim of gratuity by the claimant. On the dependent assertion, there is no time frame within which gratuity must be paid, and that the claimant must wait until her turn comes in accordance with the batches determined by year of retirement, and that the claimant will be paid her gratuity is legally untenable. It is to be remembered that claim for gratuity forms part of terminal benefit of employee, which must be paid without any delay within a reasonable time. What constitutes reasonable time depends on the circumstances. In the case at hand, the claim is that of gratuity. This is entitlement when it this is an entitlement that is expected to be paid upon retirement to enable employees settle for retirement life. To withhold such entitlement from 2019 to 2022, when this case was brought to court, until date of judgment, which is almost 6 years, is manifestly unreasonable and cannot and constitute a breach of contractual obligations. In the case of Chukuma versus Shell Petroleum, the Supreme Court has held that where an employer fails to pay terminal benefit as stipulated in the contract of service, such failure constitutes a breach of contract, and the employee is entitled to seek judicial enforcement of the right to payment. Therefore, in this case, the dependents are in breach of their contractual obligation. In view of the decision of the Supreme Court above, the defendants in this case cannot be allowed to use administrative convenience, budgetary constraint, or existence of batch system as justification for indefinite delay in fulfilling legal obligation. If this court sanctions such a move or approve such flimsy excuses, it will render employment contract illusory. This court must reject and not accept such kind of arrangement, as approving such action will deprive employee of their legitimate entitlement to gratuity. On the claim for 1.5 million as solicitor's fees and cost of litigation, the defendant's argument that the claimant would not have paid solicitor's fees because the claimant and her solicitor are married is misconceived and irrelevant. The award the payment of solicitors the relationship between a party and their legal practitioner does not extinguish the right to claim cost or legal fees. Legal services rendered remain professional service, and the fact that spouses may have a personal relationship does not negate the professional nature of the legal representation. In Samuel Lambert and others versus Chief ASBC Okujagu, the Court of Appeal awarded cost to a successful party based on what was reasonable in the circumstances. The court will consider the merit of the claim, and if it is found to be meritorious, will determine appropriate amount to be awarded based on the facts as disclosed in the case. There is no doubt the claimant engaged services of solicitor to prosecute this case, and in the process must have incurred expenses such as filing fees and other legitimate payment made in the course of prosecution of the case in court. The law is that you cannot, however, for the claim for solicitor's fees, the law is that you cannot pass the fees for engagement of your for the engagement of services of a lawyer you retain to your opponent. To your opponent. In the circumstances, the claimant is not entitled to claim solicitor's fees in this case. However, the general rule is that costs follow event, and this is at the discretion of the court. For costs that can be awarded, but is at the discretion of the court. On the claim for interest, the defendant assertion that there was no agreement for payment of interest and cost does not constitute a valid defense to the claimant's claim. Interest. The courts have inherent jurisdiction to award interest on judgment debts and on liquidated sums wrongfully withheld. The claimant's claim for interest but this depends on the circumstances of the case. But for pre-judgment interest that cannot be awarded at the discretion of the court, it has to be with the agreement of the parties. Where there is no agreement, no such interest can be paid. It is only interest on the judgment sum that the court can award at its own discretion and not as per specific request. Like cost, which is at the discretion of the court. Interest on the judgment sum can be also granted by the court at the discretion of the court, depending on the parts of the case, because it is regulated by the rules of court and circumstances of the case. The last defense put up by the defendant is their contention that the claimant's action is premature and in bad faith because she will be paid when her turn comes is wholly without merit. Let me say that in law, where a right has crystallized and the obligor refuses or delay to performance without justification, the creditor is entitled to seek judicial enforcement immediately. The claimant's right to gratuity arose upon retirement in 2019. The fact that the government has chosen to adopt a batch system does not render the claimant's claim premature. On the contrary, the prolonged delay justifies the institution of this suit. In case of Aliu Bello and others versus Attorney General of Oyo State, the Supreme Court held that courts are more interested in substance than in mere form, and the reliance on technicality lead to injustice. The court will not permit government to use administrative processes as a shield against the fulfillment of clear legal obligations. From all I have been saying above, the claimant has successfully proved her entitlement to payment of gratuity in the sum of 10,769,220 naira. The defendants are hereby ordered to pay the claimant the said sum of 10,769,220 naira as her legitimate gratuity for services for 35 years meritorious service rendered to the state. Let me say here, the attitude of some government officials while in service and public officers need much to be desired. Their notion of not minding the impact of their actions on life of others is condemnable. Their refusal to do what they were supposed to do while in service, basking under the euphoria of government is continuous, is a clear evidence of their betrayal of the trust reposed on them by virtue of the positions they occupied when they were to act and refused to act, and shift their responsibility to when they are no longer in service. The mere fact that government is continuous should not be an excuse for not acting when it matters. Public officials should always remember the day of reckoning in their action. Let me say no more on this. The claimant is not entitled, as pointed out earlier, the claimant is not entitled to solicitors to be granted solicitor's fee, but she is entitled to cost as a successful party. In the circumstances, I award 500,000 naira as cost. All the monetary award in this judgment are with immediate effect, and failure to settle the judgment sum will attract 10% interest per annum, simple interest per annum till liquidated. Judgment is hereby entered accordingly.
As the court pleases.
My Lord, we are very much grateful. We are much obliged for the industry.
You are welcome.
God for this important judgment. We wish you
Yes,
continuous
thank you.
Even when
Registrar, call the next case.
Yes, my lord.
Thank you, my
Suit
Lord.
number
You are welcome.
Suit number NICS CA 12/2024 between one Mr. Ubong Hilary Silas, Mr. Ethan Isongongo Donald, and High Quality Bakery Limited.
Present.
My lord, the second claimant on record.
No, the defendants.
The second claimant on record, my lord, is present.
The defendant is represented. Not...
Hey, listen, please. We are in court. Don't talk anyhow. Who is the first claimant?
My lord, the second claimant on record.
I say, who is the first claimant? Call the name.
The first claimant is Mr. Ubong Hilary Silas.
Is Ubong online?
My lord, Ubong is online.
Ubong, is he online?
No, my lord, he's not online.
Who is online? Who is the second claimant?
My lord, here is the second claimant. Is someone with you, Mr. Ethan Isongongo Donald.
Okay. Dependent is represented by who? Dependent is represented by who?
High quality, your name.
Dependent is represented by who?
My Lord, Victor Egba Esquire, I'm representing the defendant.
I did not call for appearance. I'm still recording the appearance of the parties. Second claimant online. I'm asking who is representing the defendant.
Lord, the defendant is represented.
Represented by who? Second defendant, is he represented
My Lord,
by
is
who?
Mesha Nyong.
I cannot hear him. I can't record.
Mr. Mesha Nyong.
If I cannot hear him, I can record him. Please, counsel should announce their appearance.
My Lord, is Mesha Nyong.
Yes, counsel should announce appearance.
My Lord, with respect, my Lord, Innocent Okon for the claimant.
Innocent
Okon, my Lord.
Innocent Okon.
Yes, my Lord, for the claimant.
Okay. Yes, appearance for the defendant. Appearance for the defendants.
Respectfully, my Lord, Victor Egba. Respectfully, my Lord, Victor Egba for the defendant.
Counsel, I can't hear you. Talk loud.
Respectfully, my Lord, Victor Egba, my appearance is for the defendant.
Victor.
My Lord, Victor Egba, my appearance is for the defendant. My lord, can you hear me, sir?
Yes.
Victor Egba.
Okay.
For the
Victor
defender.
Egba for the defendant.
Yes, my lord.
This matter is for judgment. The judgment is ready. It will be read shortly. Yes, this is the judgment of the court by the general form of complaint dated 13th day of February 2024 and filed on the same date, accompanied by a statement of facts, witness statements on all, list of witnesses, list of documents to be relied on at the trial. The claimants instituted this suit against the defendant, wherein they claim certain reliefs as follows. I'm going to skip reading the reliefs. The claimant I'm going to skip reading all the preliminaries, please, for sake of time. The case of the claimants is captured in the body of the judgment. The case of the defendant is captured in the body of the judgment. The submissions of counsel for the defendant is captured in the body of the judgment, wherein the 4 issues were formulated and the argument on the 4 issues have been captured in the body of the judgment. So I skip reading the argument. I now move to the submissions of the claimant. The claimant formulated 3 issues. The argument of the claimants have been captured in the body of the judgment, together with the responses made to the defendant's address. I now goes to the judgment or decision of the court. I now goes to the decision of the court. This is the decision of the court. I have carefully perused the processes filed in this suit by the parties, the evidence laid at the trial, as well as the written and oral submissions of counsel for the parties. From the pleading and evidence before the court, the case of the claimants borders on alleged deduction of 20% from their respective salary for 2 years without remittance of same into their retirement savings account with NPFL pensions fund administrator. There is also the claim for terminal benefit as provided for by the employee handbook. The conditions of service governing the employment of the claimants with the dependent by the translucent and unambiguous provisions of section 131, 133 of the Evidence Act as amended. A party who claims entitlement to certain rights has the burden of proving entitlement of the rights being claimed. He who asserts must prove. The claimants in this case who want this court to render judgment in their favor are duty bound to prove entitlement to their claim before the court by credible, admissible evidence if they want this court to enter judgment in their favor. There are a total of 7 reliefs being sought by the claimants. The first to fifth reliefs are on the 20% deductions from salary for 2 years without remittance into the claimant's retirement savings account with NFPL Pension Fund Administrator, and 20% claimant's salary for the number of years they respectively serve the dependent as terminal benefit as provided for in Employee Handbook Exhibit 6. The sixth relief is for 10 million naira general damages, and the seventh relief, which is the last, is for the sum of 2 million cost of this action. I shall first consider the reliefs on 20% deductions from salary for 2 years without remittance of the same into the claimant's retirement savings account with NPFLA Pension Fund Administrator. From the pleadings and witness statement on oath, the first claimant is claiming the sum of 240,000 naira in figures, and in word, he is claiming the sum of 250,000 naira as 20% deductions from his salary for 2 years without remittance to the pension fund scheme. For the second claimant, his claim is for the sum of 320,000 naira, being 20% deduction from second claimant's salary for 2 years without remittance into retirement savings account with NPFLA Pension Fund Administrator. The dependent denied deducting 20% from claimant's salary as pension deduction. The dependent stated that the deduction of pension contribution from claimant's salary is as allowed by Pension Reform Act 2014. The contribution of the dependent as employer of the claimant was 10%, while that of the claimant contributed 8%, which was deducted and paid into their retirement savings account with MPFL. The Pension Reform Act 2014 has made provision for 10% contribution by the employer and 8% contribution by the employee to be deducted from salary. The employer and the employee's contributions as provided for by the Pension Reform Act are paid into the retirement savings account of the employee with pension fund administrator. In this case, the pension fund administrators of the claimants is NPFLA. The Pension Reform Act has made provisions for an employee to make extra or additional savings into his retirement saving account. In the case at hand, the claimant have asserted that 20% were deducted from their salary for 2 years without the said 20% deduction remitted into their retirement savings account. If this claim is true, if this claim is true, the defendant would have been found to have violated the law. The defendant disputed this claim. With the disputation by the defendant of this allegation, it has now become incumbent on the claimant to prove their assertion with credible admissible evidence. Otherwise, their claim will fail due to lack of proof. As the law is tried, he who asserts must prove. I have scrutinized Exhibit A to M tendered by the claimant in support of their case, but there is no I have scrutinized Exhibit A to M tendered by the claimant in support of their case, but there is no iota of evidence adduced by the claimants to support their claim for 20% deductions from their salary for 2 years and non-remittance of same into their respective retirement savings account. The claimant would have succeeded if they had tendered their pay slip or bank statement of account or any other document to show that there was actually a deduction or an agreement for deduction of the 20% to be deducted from their salary and the same to be remitted into their respective savings account. But there was no such evidence before the court. I am in agreement with the defendant that the law permits deduction of 8% from employees' salaries as his or her contribution to be paid into his retirement savings account. The law has equally mandated the employer to contribute 10% claimant to contribute 10% of claimant's salary to be paid together with the claimant's contribution into the claimant's retirement savings account. The claimant have also failed to call officials of MPFL that told them that the defendant has not remitted their contribution into their savings account. Exhibit L cannot be of any assistance to the claimant. The claimant said, as the said statement of account was for a quarter ending 31st day of March 2018. Exhibit L is also evidence of in proof of 10% and 8% contribution that the claimant deducted from claimant retirement savings account. In view of the foregoing, the claimants have woefully failed to prove alleged 20% deductions from their respective salaries for 2 years without remittance into their retirement savings account, as there was no such evidence from their pension fund administrator. While the claimant assertion of a 20% deduction was not substantiated by payslip, but the defendant has admitted a specific remittance that is 3,920 for the first claimant and 6,000 for the second claimant. However, the absence of clear evidence of remittance, however, Exhibit L is a clear evidence of such remittance into the claimant's pension account. It is pertinent to point out here that the Pension Reforms Act requires proof of remittance from the employer to prove remittance once the employment relationship and the existence of a pension scheme are established. In this case, there is no dispute regarding employment relationship. Only the area of dispute is regarding deduction of 20% and remittance of same. And as found above, there was no such deduction by the defendant. In the circumstances, the allegations that 20% was deducted from claimant salaries fail, and same is hereby refused. Let me make it clear, very clear, that even if there is unremitted amount which the claimants are entitled to are paid directly to their retirement saving account and not to them as they claim in this case, as pension deductions are paid directly into the retirement savings account of an employee. I now turn to relief 4 and 4, which are for the sum of 1,080,000 naira, being 20% of the sum calculated as the first claimant's pay, and the sum of 2,520,000 naira being to be paid to the second defendant. This concerns the claimant's eligibility for terminal benefit based on their length of service. The defendant's handbook, as per Clause 6.5 of Exhibit A handbook, has made provisions for entitlement to terminal benefit upon resignation. The handbook requires an employee to serve for a minimum of 5 years of service for an employee to be entitled to pay of benefit. The first claimant served for 9 years, and the second claimant served for 14 years. This clearly shows that the claimants have met the requirements for entitlement to terminal benefit as per clause 6.5 of the staff handbook. The claimants have argued in their address that the refusal to pay their entitlement, coupled with the illegal withdrawal of pension deductions, constitute a breach of employment contract as defined by the handbook. The defendants has, by the paragraph 7 of the amended statement of defense, stated that the defendant did not refuse to pay claimants gratuity entitlement which is 20% of the claimant's salary for number of years they respectively worked for, in line with the defendant's employee handbook as per clause 6.5, but that the defendant only asked for some time to make requisite calculation and effect payment, but the claimant refused and went ahead to institute this suit on 13th day of February 2024. The only area of dispute now is on the quantums of claimants The pleadings and evidence before the court have clearly shown that the defendant have admitted non-payment of the terminal benefits of the claimant. Therefore, the claimant's burden was lessened in proof of this entitlement. The only area of dispute now is on the quantum the claimants are entitled to as their terminal benefit as per clause 6.5 of Exhibit A, the conditions of service, which has made it very clear that I now quote, any employee leaving the service of the defendant or retirement, resignation, and termination, not summary dismissal, with a minimum of 5 years of service shall be entitled, could be assessed in line with the stipulated in the Pension Act as amended, gratuity equal 20% of gross salary for the number of years completed. Any employee who did not resign properly as provided for in the condition of service or dismissed for misconduct shall not be eligible to any gratuity. The gratuity comes in addition to their pension contribution, which is managed and could be accessed in line with the stipulations in the Pension Reforms Act as amended. It is clear from the foregoing provisions of Exhibit A, Staff Handbook, that the claimants have served the dependent for more than 5 years. Therefore, they are qualified to be paid 20% for the number of years they have served the dependent as gratuity for the court to ascertain whether what the claimants are entitled to as gratuity as per clause 6.5a is the correct amount. The claimant are required to establish before the court what is their gross salary per month. If the claimant salaries are ascertained, the 20% of the said salary will be multiplied by number of months for the year, and the claimant serves the defendant. If there are pleadings and evidence on oath, the claimants have given their salary. In their pleading and evidence, the claimants have given their salaries to be 37,000 naira for the first claimant, and it was increased to 50,000 naira, while the second claimant's salary was given as the sum of 65,000 naira, which was later increased to 75,000 naira per annum. However, the defendant has denied and to support its position, the defendant tendered Exhibit DWE payroll for October 2023 salary. In the said payroll, the gross salary of the first claimant was put as 49,000 naira, while that of the second dependent was given as 75,500 naira. In view of the absence of payslip from the claimant, which would have been conclusive which would have conclusively established the claimant's gross salary. I have no choice than to accept the version of the defendant's salary on the salary of the claimant. With the finding of the gross salary of the claimant, the 20% of the first claimant salary per annum will be the sum of 1,580,58 naira for 9 years. This is arrived at when 4,900,000 naira based on the ascertained salary of the first claimant, which amount to 9,000,000. No, based on the ascertained gross salary of the first claimant, which is 49,000 naira. The 20% of 49,000 naira will be the sum of 9,800 naira. If this amount is multiplied by the number of months in 9 years, the total amount that will be arrived at is 1,058,400 naira, while the second claimant's 20% for 14 years of service will come to the sum of 2,536,800 naira. If the 20% of the gross salary of 75,500 naira is ascertained, then and multiplied by the years the second claimant serves the dependent, his 20% will amount to 2,536,800 naira. With this finding, the claimants have proved entitlement to relief 4 and 5 respectively, same as are hereby granted. Relief 6 is for the sum of 10 million naira as general damages. The law is well settled that general damages cover losses which are not capable of exact quantification. They do not need to be specifically pleaded, although some evidence of damages is required. See the case of Abi versus CBN. The law will presume its general damages to be direct, natural, or probable consequences of the act complained of, but the quantification thereof is at the discretion of the court. See the case of Ijebu-Ode local government versus Adedeji Balogun and Co. Limited. See also a segment versus Agolo. See also Badmos versus Adegunde and Ajiboso versus Renault. This implies and is not This implies that general damages is not specially pleaded. This includes compensation for pain and suffering and the likes, and if the injuries suffered are such as to lead to continuous or permanent disability, compensation for loss of earning power in the future. See Obasui versus Business Ventures Limited. As far as the facts of this case are concerned, there is no evidence of damages occurring to the claimant. In the circumstances of this case, the court having granted claimant's claim on terminal benefit, it will amount to double compensation to grant general damages to the claimant, more particularly when there was no evidence of the damage suffered by the claimant. This means 6 reliefs fail and same is hereby dismissed. The last relief is relief 7, seeking for payment of second 2 million naira as cost of this action. There is no evidence adduced to show how the claimants expended the 2 million naira in prosecuting this case. However, since the law is that cost follow event, I award 500,000 naira cost against the defendant in favor of the claimants. For purposes of clarity, the orders of the court are as follows. The first claimant is entitled to the sum of 94,080 naira. No, the first claimant has proved entitlement to terminal benefit of 20% of his salary for 7 years. For the 9 years he serves the dependent, as granted as per clause 6.5 of Exhibit A, the staff handbook. The dependent is hereby ordered to pay the first claimant the sum of 1,058,400 naira, being 20% of his salary of his gross salary of 49,000 naira for the number of years he has served the dependent. The second claimant is entitled 20% salary for the number of years he has served the dependent at the gross salary of 75,500 naira per month. The dependent is hereby ordered to pay the second claimant the sum of 2,536,800 naira as 20% of his salary for the number of years he has served the dependent at the gross salary of 75,500 naira. Relief 6 failed, same is hereby refused. The claimants are entitled to costs which I have assessed at the sum of 500,000 naira. The claimant, the monetary monetary aspect of this judgment shall be settled by the defendant within 30 days from today, from the date of this judgment, failing which interest of 10% per annum shall apply. This judgment takes me this 10% interest shall apply per annum. Judgment is hereby entered accordingly.
As the court pleases.
As the court pleases. My Lord, we are grateful. We thank the court so much for a well-considered judgment. Thank you, my Lord.
You are welcome.
Thank you, my Lord.
You are welcome. Registrar, any other matter for today?
That's all for today, my Lord.
Okay, thank you. Thank you, counsel, for being with us.
Thank you, my Lord.
Okay.
My Lord.
We have come to the end of today's sitting.
All right.